5. Rights and obligations. After marriage, when there are no disabilities or statutory prohibitions and a marriage takes place, there are certain rights and obligations which affect both parties. No branch of the law shows greater evidence of the changing times and the effect of modern thought than that which refers to domestic relations. These changes have not come about all at once but have developed through the ages. In the Babylonian civilization, women were considered, both physically and mentally, inferior to men. And through the Hebrew, Greek, and Roman progression, the same feeling prevailed: the right to chastise and restrain. Blackstone said that in England during his lifetime a man had a right to mildly chastise his wife with a stick no thicker than his thumb, though he added that the exercise of this privilege was mostly limited to the lower classes. Today the husband is looked on as the guardian and protector of his wife, and it is unlawful for him to strike her. The husband who does this can be prosecuted for assault and battery, providing his wife will testify in court against him, which she is not always willing to do. Perhaps this reluctance on her part goes back to the time when a husband was lord and master, and carries with it a fear of consequences in the marital relationship. Or doubtless some women are definitely masochistic and enjoy being beaten by their husbands. A case in Alabama involved a husband and wife who were emancipated slaves, and such treatment was considered a relic of barbarism, and not a part of Alabama law. The facts were that the father was chastising his child, and his wife interfered as she thought the punishment excessive. The husband struck her twice on the back with a board, and she returned the blow. He was fined for this. It is said today that a husband can restrain his wife from committing a crime, a tort for which he would be responsible, or perhaps from interfering with the proper training of his children if he is the sole guardian. A husband's responsibility for crimes. At common law, if a woman committed a crime in her husband's presence, or near enough to be under his influence and control, he was responsible and she was excused from blame, as it was presumed that she acted under his direction and was coerced. This rule did not apply to crimes of a grave nature, and today if a woman voluntarily commits a criminal act, the responsibility is hers and is not placed upon her husband. But if she is in his presence, there may be a presumption of coercion. Marriage made the husband and wife one at common law, and, as he was the one who represented them both, they were not liable for larceny or burglary from each other, as it was not possible to steal from oneself. Because of their unique relationship, it became the rule that they were not criminally guilty of acts against each other which, if perpetrated against anyone else, would be crimes. There was an exception to this rule when either one killed the other, for then the killer was liable for homicide. Today either one is criminally liable for an assault and battery on the other, though the injured party may not recover damages. An Iowa court held that a wife had the right to bring an action against her husband when property was involved, but she could not sue him for damages for 11 distinct assaults and batteries. A husband or wife could not be guilty of arson against the other, for at common law arson meant the burning of the house of another, and they were legally one. Responsibility for torts. A tort is an unlawful violation of a private legal right not created by contract, which gives rise to an action for damages. At common law, a husband was liable for torts committed by his wife, even before the marriage, and this liability was ended only by death or divorce. As a general rule, wrong acts, as well as crimes, committed in the husband's presence were presumed to have been at his direction or command. This is changed by statute, and in most states a husband is no longer liable for his wife's wrongdoing unless he actually participates, but in a few states he is still liable for slander and assault and battery, even though committed in his absence. Of course, by reason of the unity between the two, they were not responsible for torts against each other, but both now have a right of action when there is a wrong committed by a third party against the wife which results in an injury to her. In case of accident, she can recover for mental and physical suffering, and the husband can recover for the loss of services and the loss of her society to which he is entitled. At common law, a suit for damages for personal injury to her had to be brought jointly, but the husband had to bring suit alone for an injury to himself. In most states, a married woman can now bring an action as she could if unmarried, a husband's right to the society of his wife. A husband has the right of action for damages against anyone who alienates the affections of his wife, or deprives him of her companionship and services by enticing her to leave him or by harboring her. If, however, she is forced through fear of bodily harm to leave him, he cannot recover from anyone who shelters her, and her parents are not liable if they offer their daughter protection in case she is obliged to leave her husband. He can also bring an action for damages known as an action for criminal conversation against anyone who has sexual intercourse with his wife, even though there is no loss of service, as a wife is entitled to the society and companionship of her husband. Under most modern statutes, she can also bring an action for alienation of his affections, but in some states she cannot bring an action against another for enticing him away. Rights and property. At common law, a man upon marriage acquired all the personal property which his wife had in her possession. He was entitled to her earnings, income from stocks, bonds, and bank accounts, if he got them into his possession during his lifetime. At his death, they passed to his personal representative, with the exception of her wearing apparel, which she was allowed to keep. At common law, he also acquired an interest in all her real property. He could sell, assign, mortgage, or otherwise dispose of it during marriage without her consent. Real property was liable for his debts, and if he survived her, the property became his. If she survived him and he had not disposed of the property during his life, she received it. All estates in which she had a life interest became his, and he could take all rents and profits, but he could not dispose of these interests, and thereby affect her right to them at his death. The property and contractual rights of women have changed greatly since the common law was operative, and to understand how much these modifications have meant, we should consider the changes under equity, the added powers under legislation called the First Married Women's Act, and the later Married Women's Act. Trust estates for women. Prior to 1800, the Court of Chancery had been interested for centuries in making it possible for a married woman to hold property independently of her husband and to exert over it the same rights which a man or an unmarried woman could exert. This was not so much because the Court of Chancery wished to increase the property rights of married women as it was to give assurance to any person who gave property to a married woman that she could possess it as her own and deal with it independently of her husband, whose common law rights were in conflict with the principles of the Court of Chancery. This court finally achieved its objective and gave to married women practically all the rights which her husband had over property given her for her separate use. This was done by means of an ingenious but simple rule, namely, though a married woman could not hold property in her own right, a trustee could hold it for her benefit. At common law, it was still the property of the trustee, but in equity, this trustee had to deal with it according to the terms of the trust and in accordance with the wishes of the woman. This became the separate property or separate estate of a married woman. If no trustee was appointed, the husband was at common law the legal owner, but he had to hold the property as trustee for his wife. This was a great step toward establishing the legal status of women, and their rights were further extended in this country by statutes. Married Women's Acts. This first legislation gave a woman the right to hold as her separate property any real or personal property which she owned before marriage or acquired by descent or otherwise from any person other than her husband. She had sole control of it and could collect rents and receive profits from it. It was not subject to any control of her husband and was exempt from attachment or execution of his debts. The later act, about 1874, though the date varied in the different states, gave a married woman the right to convey property in the same manner and to the same extent that her husband could convey property belonging to him. A rather early case in Maine shows the working of this statute. The husband, as plaintiff, brought suit for breaking and entering and carrying away several articles of his personal property. It seemed that he had married a woman who owned a farmhouse, articles of furniture, and other personal property, and while they were residing together in this house, a third party had entered and removed certain articles. This party introduced evidence to show that the articles belonged to the wife at the time of the marriage and that they had been taken at her direction. The common law giving the husband the title to personal chattels in her possession was not in force, but instead there was a statute which provided that when any woman possessed of property, real or personal, shall marry, such property shall continue to her, and she shall have, hold and possess the same as her separate property. She therefore had entire control over it and the right to dispose of it as she saw fit. Therefore the decision was against the husband as plaintiff. The decisions in cases which involve a question of the property rights of women vary according to the statutory provision in force in the state at a particular time. That is, whether they have the rights which equity gave, additional privileges under the halfway statutes, or full powers under the later acts. Although a husband had entire control of his wife's personal property at common law, He was responsible for her debts contracted before the marriage as well as those contracted afterwards, so that the advantage was not all on his side. He was obliged, as he is now, to support his wife and provide her with necessaries suitable to their station in life. Today she is looked upon as his agent and can pledge his credit with tradespeople, contrary to the usual belief, even when he has posted her and stated in the newspaper that he will no longer be responsible for her bills, unless he can prove that the tradespeople sought the notice. Necessaries is a relative term depending upon the financial condition of the husband, and the courts have held that expensive clothing bought by the wife of a high-salaried man would be classed as necessaries and in keeping with her station in life, while the same clothing bought by the wife of a laborer would be excessive expense and not necessaries. Dower and courtesy rights. In some states today, a widow has the same dower rights that she had at common law. That is, she has a 1/3 interest for life in her husband's real property, whether there are children or not. A widow can claim 1/2 of all the property in some states, and she can waive her dower rights and take her statutory share if she wishes. At common law, a husband on the death of his wife had an estate by courtesy which entitled him to a life estate and all the real property which she held during the marriage, providing the wife had borne a child capable of inheriting. This is changed by statute in most states, but many states still require the signature of both parties to a deed in order to pass a good title to real estate and to release the respective dower and courtesy rights. A conveyance from husband to wife without a valuable consideration is fraudulent as against his creditors, and sometimes it is considered better policy to make use of the trustee in a transfer of property from husband to wife. In some states, all real or personal property acquired after marriage by either husband or wife is, by statute, community property. This is based on the theory that marriage creates a partnership, and all the property which they acquire is for their mutual benefit. The doctrine of community property was not known at common law, but originated as a part of the civil or Roman law. It was adopted by Texas and California and a few other western and southwestern states. Husband and wife as witnesses. At common law, husband and wife were under an absolute disqualification to testify for each other. They could not testify if they were parties to the suit or if the husband or wife of either was a party to the suit, because of the presumption of a personal interest in the result. The rule today is that parties to a suit may testify in both civil and criminal cases, but statutes in practically all states provide that a husband or wife shall not be compelled, or, without the consent of the other, be allowed to disclose a confidential communication made during the marital relationship, for this is a privileged communication. For instance, if a husband tells his wife that he has robbed a man, she cannot be forced to tell this. There is such an identity of interest that the courts do not favor the idea of compelling one party to the marriage to place the partner in jeopardy of punishment for a crime. Right to contract. A husband and wife could not contract with each other at common law as they were legally one person. In fact, a married woman could not contract at all unless her husband had been banished, was a non-resident alien, or was civilly dead, the term used if he had been convicted of a felony. Equity somewhat changed this and gave her certain rights, but even these were limited to contracts relating to her separate estates. That is, she could incur a debt on the credit of separate property which belonged to her at the time the debt was incurred. This property was liable to satisfy the debt. If she borrowed money and had no separate property at the time but in a short time inherited some, in equity, the money which she inherited was not chargeable for the money which she had borrowed. By later decisions, the contracts of a married woman were enforceable against her. Otherwise, she would have an unfair advantage. A man applied to a bank for a loan of $5,000 to be used in his business and offered stock as collateral. The bank declined to make the loan, but told him if his wife wished to borrow the money with the same security, she could have the loan. His wife shortly afterward signed a note which authorized him to receive the money and credit it to his business. The bank brought suit against her, and the court held that this was an individual contract of the wife as principal, and not as surety for him. The fact that she had given him the money did not lessen her liability. With the consent of her husband, a woman could carry on a separate trade or business and could contract with reference to this. Modern statutes have removed the limitations, and in most states a woman can now contract with her husband and can bring action against him for failure to perform, as she can against anyone else. While a married woman may become a partner in a firm under modern statutes, all states do not grant her the privilege of becoming a partner with her husband. Will making. At common law, the will of an unmarried woman was revoked upon marriage, as her personal property became her husband's at that time. She could not devise by will unless her husband was willing for her to dispose of her personal trinkets. According to Blackstone, it was possible for a man to make a will of personal property from very early times, but even this was limited and his property was divided into 3 parts. 1 part went by law to his lineal descendants, 1 part to his wife, and he could dispose of the remaining part as he wished. It was not until the statute of wills during the reign of Henry VIII that it was possible to dispose of real estate by will. Now, in most states, a woman can devise by will as a man can, though in some jurisdictions the property which she has the right to will away is limited, and in a few states the formal consent of the husband is necessary if the will is to be effective. It is important to know the formalities required in each state when making a will. For instance, the number of witnesses required differs in the various states. Most states by statute require 2, but some states, especially in New England, require 3. Some states also require a seal as well as the signature of the witnesses. Some jurisdictions have held that a will is invalid if one of the witnesses is a beneficiary under the will. Others hold that the will is good and will stand except for the gift to the witness, who will lose the bequest. In a New Hampshire case, one of the witnesses to the will was the husband of a beneficiary under the will, and the court held that the legacy rendered him incompetent as a witness and the will invalid. Later cases in New Hampshire have held the will void only as to the particular legacy in the will.